apologies. Thank you very much, all.
Thanks, Ronan, and just first of all to echo what Ivana said, I'd like to thank you both, Ronan and April, for organising the event and others as well, and for helping to do more to bring this important issue into the public eye. Now, I'll begin by, at the risk of repeating what Ivana said, which I agree with, I'll begin by saying that there's been a great deal of attention focused in recent years on issues around religion and equality in schools, but there's been remarkably little progress. And what I want to focus on today is how the Constitution in particular has been used to rationalise that and to justify or to excuse the lack of progress or the very, very weak character of the progress that has been achieved on those fronts. And what I would argue, what I do maintain, is that the Constitution has been wrongly used to deflect political responsibility and particularly legislative responsibility concerning the role of religion in our schools. There are, and as Ivana said, there are three major and long-standing problems with respect to religion and equality in our schools. The first is the lack of alternatives to Catholic schools in many areas of the state. The second is the clear absence of legislative safeguards for religious and non-religious minorities attending Catholic schools. Now, we don't mean ministerial circulars or well-meaning guidelines, we mean legislative safeguards, sources of rights. And thirdly, what I would focus on, the third issue, is the discrimination experienced by unbaptised children in accessing state-funded schools. Now, under each of those three headings, there has been remarkably little progress under each of those three headings, and the lack of progress has been rationalised not only with reference to a supposed political realism or political expediency, it has also been justified with reference to high constitutional principles. And specifically, the idea, or the theory that has been invoked, is the idea of freedom of religion. And it seems odd at the outset to say that the practice of religious discrimination in state-funded schools has been justified with reference to an idea of freedom of religion. It seems odd because it is. It sounds bogus, and you might have a suspicion that a lawyerly artifice, or that it is bogus. It sounds bogus because it is. My aim here is to outline why I believe that the constitutional barriers to reforms have been overstated, and to discuss a little bit how the constitutional narrative has been captured and set by the most powerful vested interests in this domain, and why we shouldn't necessarily surrender to a legalistic narrative which attempts to divest and reflect responsibility away from the political and the legislative spheres. So what are the supposed constitutional barriers to reform? Now, the assumption that has predominated has been that since the Constitution protects freedom of religion, in rather vague terms it must be said, therefore religious schools, even where state-funded, cannot be required to limit or to restrict the role of their religious ethos in any aspect of the school day, and therefore that they cannot be forced to adopt admissions policies which would undermine the ethos of the school, because somehow that would restrict the right of Catholic or Protestant parents to freely practice their religion. And that is effectively the rationale, that is the official rationale behind the Equal Status Act, and specifically Section 7.3c of the Equal Status Act, which effectively permits state-funded denominational schools to discriminate on religious grounds. It has been said at official levels that the exemption for denominational schools is not only permitted by the Constitution, but is actively required, actively mandated by the Constitution. Again, the thinking behind it is that if denominational schools were prohibited from selecting on religious grounds, it would undermine their ethos, and in turn, therefore, it would interfere with the constitutional right of the majority parents, to use that phrase, to have their children educated in a properly religious environment. And in fact, when the bill was introduced in 1997, the Equal Status Bill, The exemption was defended by Mervyn Taylor at the time on the basis that it would uphold the freedom of religion of minority schools. Minority schools, Jewish and Protestant schools in particular, whose character would otherwise be diluted and who would no longer have the capacity to cater to discrete religious minorities. But of course, in practice, as we all know, that's not how it has worked out, and anybody at the time would have been able to tell that's how it wouldn't have worked out like that. In practice, the exemption has been used to justify a range of egregious abuses, which in fact often have very little to do with religion, or have less to do with religion per se than is often admitted. We hear of complex, multi-tiered admissions policies based not only on whether the applicant's children are baptised as Catholics, but in some instances based on whether both their parents are Catholics, and there being tiers of Catholicity, if you can say that. And also there being a distinction in some cases between so-called born Catholics and convert Catholics, and who says that considerations of pedigree have no place in a republic. And by the way, it's not even clear that those kinds of distinctions are permissible even within the existing legislative framework, because I'm not quite sure what the religious or the theological justification for them is. And that shows us that in fact it often has little to do with religion as such. It's yet another subtle mechanism of social filtering of the kind that unfortunately is so commonplace in the education system more generally. It isn't just about religion, actually. And there is evidence that the exemption has been used as a proxy for discrimination that is linked to ethnicity and race. In 2007, for example, a so-called emergency primary school, was opened in North Dublin to cater for children from various African nationalities who couldn't find a place in any state-funded Catholic school, and who were reportedly told by some of the schools that we look after our own first. Now, I'm not sure whether our own refers to Catholicism in that case, or refers to considerations of nationality, ethnicity, and race. So how could that state of affairs possibly be justified by a principle of freedom of religion? Now, that is the official rationale for maintaining the status quo in place. And when the present Minister for Education said earlier this year that any removal of the exemption would need a constitutional referendum, I understand that that's what she meant. That's the narrative that has been set around what the Oireachtas can do. The narrative has been that the hands of the Oireachtas and of the government are tied by the Constitution, and that the only solution is to have a referendum, and that we have some kind of quota on progressive referendums, and so we're not ready yet for another one. That is the implicit thinking behind it. But we probably didn't need a referendum for marriage equality, and we definitely don't need a referendum for this. The idea behind it is that religious freedom means that parents and children have the right to be educated in an unfettered, uncompromised religious environment, and that any denial of the so-called right to discriminate would interfere with that right to have a properly religious environment in the school, and therefore the right to freely practice a religion in the educational context. Now, the assumption has been that freedom of religion and religious equality are in tension, that they are in conflicts, that they are in opposition, and that since religious freedom is more important, religious equality must be sacrificed or compromised for the sake of freedom of religion. That might seem somewhat illogical, it might seem intellectually vacuous, it might seem to interpret the idea of freedom of religion in a way that favours the position of the majority, or the position of those with more social power, or those with access to the avenues in which these constitutional arguments can be forwarded. And you might think that surely an integral part of freedom of religion is the right not to be discriminated against on the grounds of religion. But that, in fact, the opposite has been assumed. It has been assumed that what religious freedom means is not the right to be free from religious discrimination in a state-funded quasi-public context, but rather that religious freedom is the right to discriminate, that it's an exercise of freedom of religion. There is a lot of lawyerly artifice, obviously, around this, but that's what it boils down to. That's the basic idea. And if it sounds suspicious, if it sounds bogus, that's simply because it is. So we have, again, the dominant narrative has assumed a tension and opposition between those ideals, but intuitively we know that non-discrimination and freedom are two sides of the same coin, and that the opposition between them in this context is an artifice, and it's an artifice which has been successfully constructed and maintained by a set of powerful vested interests. Okay? So how did that come? I mean, how does this come about? How do the lawyers simply get it wrong? How did it come about that a situation where evidence of religious affiliation is a condition of accessing public services could be justified by a principle of freedom to practice religion? How could that possibly come about? Can it really be constitutionally required? Now, I mean, we all have a sense sometimes that lawyers exist to tell us what we can't do. And that is true in politics and in legislation, as it is in other domains. And we also like to imagine, or some people like to imagine, that law and constitutional law is a precise technical science, and that it operates independently of politics or of political considerations. That's quite false. You can't interpret principles, vague principles in a constitution without reference to political and moral values. In reality, interpreting a constitution isn't a precise technical science. It is wholly intertwined with political and moral values, and claims about what constitutions mean are often intertwined with the ideological worldviews and the interests, the economic and social interests of powerful sectors of society. We imagine that where lawyers say that the Constitution prevents reform of this kind, we imagine that that is a technical, lawyerly assessment, but in fact that is simply an extension or a reflection of the ideology, first of all, the ideological worldview, and second of all, the interests of certain vested interests in the education sphere. And we often assume that the Constitution exists and serves to protect the rights of individuals and minorities, and lawyers are often keen to emphasise that. But what we probably overlook is the extent to which the Constitution has successfully been instrumentalised and used by powerful vested interests, often to resist modestly progressive social reforms. And this is just another instance of that. Okay, the refusal or the reluctance to amend or to repeal Section 7.3c of the Equal Status Act. It has been rationalised with reference to the Constitution, but that is about as much about politics as it is about law per se. Okay, now, I mean, that's what I say, but ultimately, of course, someone might argue back at me that it's all very well for me to say that, but that if the exemption were repealed by the Oireachtas, that might be struck down by the courts. Ultimately, of course, it comes down to what the Supreme Court or the High Court might say on the issue. And it is true that the constitutional principles in question have often been interpreted in a very conservative way. And so that whatever I might say, there is a risk that any reform might be struck down by the courts. But I don't even think that is true. I think that risk has been exaggerated. The courts themselves have repeatedly recognised that the Oireachtas has a very broad margin of discretion in how it addresses and deals with these issues, and in particular how it weighs up and balances competing rights or competing claimed rights in various contexts, and how it weighs up considerations of constitutional rights against the common good. The primary responsibility for balancing rights is not for the courts, it's for the Oireachtas. It's for the Oireachtas to exercise that responsibility, and the courts will only strike down legislation as being unconstitutional if the Oireachtas strikes the balance in a disproportionate way. And I don't think anybody could really say that it's disproportionate to require as a condition of state funding that schools admit children without consideration to religious affiliation, as much as without consideration to pedigree or consideration of a racial or an ethnic nature. The argument, of course, the argument can be raised that such legislation would be unconstitutional, but that argument, as Eoin I'm sure would agree, that argument can be made in relation to vast swathes of legislation. We shouldn't accept that as a pretext for inaction. We shouldn't accept that as a pretext for the Oireachtas failing to exercise its responsibilities in this domain. We cannot allow the Constitution to be used as a pretext for inaction. As things stand, the Oireachtas could remove or drastically narrow the exemption that is provided by Section 7.3c, and in fact, a private member's bill, is already before the Oireachtas to repeal Section 7.3c of the Equal Status Act. And regardless of party political affiliation, I think everybody would do well to support that and bring that into the public eye, and to support the idea that the government not only should, but that it can in the first place accept that bill and allow this exemption, which has caused so many difficulties for so many people and has no real justification with reference to public policy, to allow that exemption to be repealed. Now, before I finish, I would just like to say that the conservatism and the lack of progress around equality and religion in schools has been felt as much in relation to the other two issues I mentioned as it has in relation to the admissions issue. I would differ slightly from Ivana on the question of Rule 68 of the Rules for National Schools having been repealed. It's not that I wouldn't welcome it, I just think that its significance has been vastly overstated. The Rules for National Schools are not law, they're not legislation, they're not a source of rights, and the repeal of Rule 68 is really little more than a symbolic gesture. It does nothing, actually, to provide firm guidelines, firm safeguards concerning how members of religious and non-religious minorities should be accommodated within the school environment or within the school day. It says nothing about the practice of the integrated curriculum, which permits the religious contents of the curriculum to permeate the whole school day and to permeate the secular curriculum as well, and which makes it so difficult for parents to exercise their right to opt out. So, to an extent, the government narrative around the repeal of Rule 68 simply has been repeated by the media rather uncritically. The idea that the integrated curriculum is to end, the idea that the rights of religious minorities in state-funded schools are to receive better respect. There's no indication that the reality will change. The reality on the ground will change because of the amendments of Rule 68. What we need is an amendment to the Education Act which sets down firmly in a legislative form what state-funded schools are clearly required to do in terms of accommodating religious minorities in the school day. Anything else is simply platitude, and the repeal of Rule 68 of the 1965 Rules for National Schools unfortunately falls in that category. Okay, so to finish, I'd like just again to thank the organisers and to wish you the best of luck in this very important campaign. Thank you.
Thank you very much, Alan. I think that was probably one of the best kind of summing ups of the issue I've actually heard to date. So thanks very much, Alan. We have a small gift here for Owen and Ivana. Just to say thank you. We don't have one for everyone in the audience.
I'm glad Owen's getting the pink one. I didn't say that.
We planned that. But what we do have for you is your chance to jump in on the discussion, ask questions.